Is there like a dollar value after which you say, oh, hey, I want to pursue this in a litigation in a court?
Because of the cost of proceeding, you may win the battle but lose the war. Is this a defining situation for your company? The fact of the matter is that 95% of lawsuits do not go to litigation, and they get settled somewhere along the way.
Specifically with scope gaps, what's the best way to resolve this?
I always think of it as a game of musical chairs. When the music stops, does somebody not have a seat? And there always is, right? There's always scope gaps on projects.
What are some of the common mistakes they do while negotiating or writing their subcontract agreements?
They recycle contracts over and over and over.
Have you seen a change after the pandemic in escalation clauses? Like, how do you strike a balance between getting the work done, maintaining a relationship, but then also managing the contract?
I'm a fan of formal or informal escalation of disputes. How can I help them? Is there a way I can call them? And what's my tone?
What are some of the pointers that you would say good documented email would look like?
Here's the problem, maybe a document or two that attaches it. Here's our position, and here's what we want.
In today's episode of Constructing Tomorrow, we have Greg Holness. He currently works as an operations director with Arcadis, where he manages the contract solutions team. He has more than 3 decades of experience in construction disputes. He has previously worked with Department of Transportation, couple of subcontractors, and several law firms where he has reviewed and resolved more than hundreds of claims related to schedule, productivity, and interpretation of contracts and specifications. He has worked on both public and private projects. In this episode, we break down concepts of mediation, arbitration, and litigation, how to manage scope gaps, how to avoid some common mistakes while negotiating and writing contracts, best practices to document throughout the project, difference in legality when it comes to private versus public entities, tips for managers and young professionals to manage contracts, and much more. With that said, I bring you Greg Holness.
Hi, Greg. Thanks for being here and welcome to the podcast.
Yeah, no problem, Sid. Thanks for asking me to join.
I am super excited to learn more about construction law and contracting. But before we dive right into all the specifics, I wanted to know how you got into construction and then what sparked your interest in the law side of things.
Sure. Like many people in construction, I sort of fell into it. I graduated from the University of Connecticut with a civil engineering degree, and it was a tough economy, and I was able to get a job at the Connecticut DOT, and it just so happened that that job was in construction claims analysis, and I liked it. So I didn't know anything about it in college, didn't take any classes, and got the opportunity to do it and really enjoyed it. In the first few years that I was there, I was negotiating claims and analyzing claims with contractors. And I noticed that as the dollar values got bigger or the dispute got more contentious, the attorneys started to come in. And in my youthful hubris, I sort of said, I can do a better job than most of these attorneys. And so I went to school at night, and then I graduated from law school, became an attorney, and started working as a lawyer. So, and it's worked out very well. It's been fun.
Oh, how was the night school thing?
Oh my God, it was so tough. Yeah, it was so tough. I mean, it was working full-time job, and then I'd go to class for either 2 or 4 hours a night for 4 nights of the week, and then I'd study on the weekends. So it was difficult, but I loved it. I really enjoyed it.
I mean, you really have to be passionate about it to do that. Before we go into specifics, I think what I would like to do is ask some basic terms for the audience so that they can follow the conversation throughout. So the first one should be, what's the basic difference between mediation, arbitration, and litigation? We often hear these words, but what does this mean?
Sure, there are 3 different ways to resolve a dispute. So the easiest way to explain it is that mediation is a non-binding use of a third party, a neutral party, to try to get the parties to negotiate a settlement. If you don't agree to the settlement, there is no settlement and everyone walks away. So nobody forces you to agree to anything. Arbitration is a binding with a little asterisk that I'll explain. And this is essentially a less formal way of resolving a dispute, similar to court, except instead of judges or juries, the people that are deciding it are usually either one or three construction professionals, usually retired professionals. There's usually at least one attorney, oftentimes more than one attorney, and then sometimes you'll get, you know, a contractor or an engineer or an architect, somebody who's been in the industry for a very long time. And the gain there is that you don't have to explain construction. They generally understand how it works. And because it's not in a court, there's a little bit less formal discovery, there's less motion practice, there's less formality. So theoretically, it's cheaper and faster, although very big cases sometimes can take just as long as in court. And then litigation is where you go to a court, and it's not what you see on TV because there's no construction legal drama series on TV, but it is where you have a decision either by a single judge or by a jury. And again, that gets decided, and that is a binding decision. Arbitration and litigation can both be appealed. Arbitration, it's rare to have something overturned because the courts generally don't want to second guess an arbitrator. So unless there is fraud or undue influence or things like that, an arbitration is generally binding, although it can be appealed on some procedural grounds.
Got it. And with arbitration, you mentioned that there's like at least one attorney and probably a couple of subject matter experts, right? So who chooses the subject matter experts? I'm pretty sure it has to be unrelated to the two parties disputing, right?
Correct. What happens is you usually go to a dispute resolution association like the American Arbitration Association, where there's a variety of other organizations, and they have a roster of arbitrators. They usually have rosters of mediation, same sort of thing. And the parties essentially do one of two things. They either pick the one arbitrator, and there's a list that's circulated, and they can strike them, and there's usually a little bit of discussion. We both like this guy. We both like that person, or I'm not working with this person. And you come to an agreement on the one arbitrator, usually one arbitrator on a smaller dollar value, less complex case. On a larger dollar value in dispute and a more complex case, you're going to use three arbitrators. And the typical way to figure that out is either the parties agree on all three, which is less typical, but more typically, each party picks one arbitrator, and then those two arbitrators pick a third arbitrator.
So usually it's best to settle out of court because it's less expensive. Is there like a dollar value after which you say, oh, hey, I want to pursue this in a litigation in a court? So I would not say dollar value, but I would say it would be worthwhile to fight it in a court rather than settling. Like, how do you kind of decide that balance?
Well, I mean, one way that many clients decide to settle it, and I've been a client on the dispute side as well as a consultant as I am now. And a lot of times, what people look at is what is the cost. So if I'm a contractor or I'm an owner and I have a dispute, I have to sit there and say, okay, if I have a dispute and I need to get an attorney involved and I need to get a claims expert or a scheduling expert involved, or maybe a subsurface soils expert, someone that's subject matter expertise, what's that going to cost me? And in some cases, that could be $1 million. Now, not typically. I mean, mega jobs have situations like that, and I've worked on them, and they're very expensive, but there's a lot of dollars involved in them. But if you have a dispute let's say you have a dispute of $1 million on a project, or say 500,000, and you're going to spend 200,000 in attorneys and consultants, it doesn't give you a whole lot of room. And that may be one where maybe you talk to an attorney, maybe you get a preliminary evaluation from a claims scheduling subject matter expert, and then you either try to negotiate it yourself or you try to go to mediation. And that would be a situation where, because of the cost of proceeding, you may win the battle but lose the war, if you know what I mean. You win, but you've spent so much money that it doesn't matter. It's sad that that's the case, but construction is very document intensive. It's very fact specific. Um, I've worked on hundreds of projects, but each new project, it's like peeling an onion. There's just so many different layers, and they're all similar to past jobs, but they all have different facts, different contracts, different scenarios. The parties view things differently. So you can have a very similar situation, but in one it's easier to settle, and the other it's going to take forever. Just because somebody has said, over my dead body, am I ever settling this thing? And you say, okay, I guess we're going to court, or I guess we're going to arbitration, depending on what the contract requires. So, yeah, so a lot of it is dollar value. The other thing that I suggest to people when they ask, is this a case that we should go to the end on, is this a a defining situation for your company, right? For example, if you are an owner and you have a clause in your contract, say you're a state DOT, for example, and you have a clause in your contract, and if you give money on that one contract, it might be $100,000, but then everybody knows that they can get money on that clause. You may be paying it out on every single one of your projects. So your precedent may be set, and you may not want to settle it. So you may want to go to court for two reasons. One, if the court upholds the clause, then the next person that asks for it, you hold up the decision of the judge and say, see, we're on good, solid legal ground. And if the judge says, nope, that clause is not to be interpreted that way, well, then you as an agency can say, okay, based on the legal situation, we are going to change the language, or we're going to change our interpretation. And so that would be an example. On the other end, as a contractor, it might be, if you lose this case, you may go out of business, right? So this is bet the farm. But the fact of the matter is that 95% of lawsuits that are settled do not go to litigation, do not go to a hearing, do not go to a judgment, and they get settled somewhere along the way. Yeah, you can start the litigation to maybe put some pressure on the other side, because then they'll need to employ an attorney and some other consultants and things of that nature. And that may cause them to come to the table, be willing to settle more so than if you hadn't. But just because the litigation is filed doesn't mean it's going to go all the way to a hearing.
Yeah, great insights on the topic. And I have a follow-up question about, so usually you hear cases about schedule delays or cost overruns. So in your experience, what are some of the common legal cases or disputes that you have come across?
Sure. A lot of what I've dealt with, and I work as a claims consultant, an engineer now, not as an attorney, but for a good portion of my career, I worked as an attorney. And the majority of the legal issues are, what is a contractor entitled to for additional compensation or additional time, which sometimes is related to avoidance of liquidated damages, right? Liquidated damages are in a contract that says if the contractor doesn't finish the work by X date or X number of days, they will pay a certain amount per day, and that can go very much. So sometimes if a contractor is able to get a time extension, they're not getting money, but they're avoiding paying money. So it's sort of the same difference. So much of what I dealt with for, I'd say 17, 18 years as an attorney, was trying to figure out whether either the contractor that I worked for was entitled to that, or one of the clients that I had that was defending it, could show something that was not, that they were not entitled to that. In addition to that, a lot of what is the appropriate damage, even when entitled is shown. So you're entitled to a time extension and compensation for that extra time, but legally, what are you allowed to include in those damages, and how do you quantify it? And so that's what I've spent a good portion of my legal career and what I'm doing now focused on, is trying to figure out whether someone is entitled to additional compensation or additional time, and then how do you actually quantify that?
Interesting. And you mentioned about liquidated damages and how it affects either contractors or the developers, right? So one of the biggest portion of it is also scope gaps. So I was curious to understand specifically with scope gaps, say if a contractor and a subcontractor are not agreeing to a certain language in the subcontract agreement, they try to settle it. It didn't go that route. So what's the best way to resolve this?
Well, there's two things going on there that I hear in your question. One is when I think about scope gaps, I'm thinking either on the contractor side or the owner, and we'll say the upstream or the downstream, because it could be, as you mentioned, a contractor subcontractor situation. Is what was in the contract that defined what the downstream party's scope was? Okay. And so I think that you have to go back to what the definition of that scope is. And that can be in the scope exhibit, it can be in the specifications, it can be in the plans. All three of them probably combined to define what it is. And as you're aware, I'm sure, there's usually language in the contract that says if there's a conflict between any of those three, the one that requires more is typically what the scope is. So you want to check the language in your contract specifically. So the one of the issues that comes up a lot is that most contracts have, or most bidding documents have language that says something to the effect that the contractor has made a reasonable or a detailed examination of the contract documents. The site has asked all the questions that it wants, and that for the price that they are proposing, it includes all the scope that's defined. Okay, so if the contractor has that scope, but then they didn't parcel it out to the subs, and sometimes, that is the trick, then they probably don't have much of a claim against the owner because their scope may be well defined. Um, Between the different subs, it may be a situation where there is scope and subcontractor one doesn't have it, subcontractor two doesn't have it, and the contractor does have it. So, it's kind of I always think of it as a game of musical chairs. When the music stops, does somebody not have a seat? And there always is, right? There's always scope gaps on projects, and you have to kind of piece it back to, okay, the analysis I just talked about between the owner and the contractor. Okay, if you determine that, yeah, that was defined in the scope from the owner to the contractor, then you'd have to look at each sub. Was it included in what the contractor scoped out to the sub one or sub two? And if it's in there, then that's where the music ends, and the sub doesn't have the seat. But if it's not in either of those subs scope, then it falls back on the contractor. So it's really a particular analysis of what the contract defines as scope, which, as you know, can be pretty complicated depending on what exactly you're looking at.
I was also wanting to touch upon. So you mentioned a lot about the importance of contract and the language in it and how it's interpreted, right? So for contractors, what are some of the common mistakes they do while negotiating or writing their subcontract agreements?
Two things that contractors do to subs that I think get them into problems sometimes is that they recycle contracts over and over and over. So you have another subcontract, you grab the scope on the last trade that you just did, and you throw it into the new one, and you type a few new things at the bottom. And what ends up happening is maybe there was something in the previous sub scope that isn't applicable here, which now causes a bit of a conflict, and maybe it doesn't have any application. I've actually seen language in scopes that, you know, in depositions, people have said, yes, that doesn't have anything to do with this sub. that we just grabbed the contract and moved it over. But by the time we get to that point, both parties have spent a lot of money and a lot of time and energy, and somebody hasn't been getting paid. So I think whoever's writing the contract, and it's usually a mix of lawyers or templates on the contract itself, but then the scope document is often written by project managers, or if you have a subcontractor procurement department. And that's usually the trickier one. That's, I won't say sloppy, but it can be a little bit sloppier, and that can cause some problems. Because I am a big believer that if you spend a little bit of time on your contract and make it as clear as possible, you will avoid disputes down the road. If it's, you know, the same thing every third bullet point, and there's conflicts on page 2 and 4 and 3 and 5, then there's going to be a lot of disputes down the road. But if somebody has read it from beginning to end and say, okay, this all makes sense, this is applicable to this situation, you'll have less disputes. The other thing I think that contractors do, or really any party that is upstream, is they try to make the contract too onerous. They try to make it no damages for delay, you are responsible for this, and they try to shift all the risk to the downstream party. So an owner to the contractor, or a contractor to a sub. And this can work, and there are many clauses that do this that are enforceable. But I think what ends up happening is two things. I think people catch on pretty quick, and your subs are going to give GCs higher prices because they know they're not going to get more money, or they know that they're going to have a fight to get it harder. And GCs then get those prices, and they put their price up to the owner because they know they're going to have the same situation. And so I think that equitable contracts, when I drafted contracts, I used to joke and say, my contracts are as even as they can be, but realistically, they're probably 51% to me and 49% to the people downstream. So there were a couple things that I leaned my way. But as far as compensation and time extension, if we did something wrong, we were a subcontractor, but we had subs underneath us. If we did something wrong that caused that sub additional cost, then we stood up and said, okay, you have to prove it, and then you're entitled to it. But if it's something that the GC did, or something that the owner or the architect did, then it's passed through, because that's not my company. And most of our subs recognized that that was equitable, and therefore we were able to build some rapport and some relationship, and we were able to work together. So I think when they're overly onerous, it just sets up the tone early on with there's going to be a lot of letter writing, there's going to be a lot of disputes, there's going to be a lot of fights, and nobody really likes that, and that ends up being disruptive to the whole camaraderie, the cooperation, all that sort of stuff that is beneficial on projects when it happens.
You really touched on a couple of great points, but before that, I wanted to ask you about like specific clauses in the contract, right? Have you seen a change after the pandemic, and maybe an additional language in escalation clauses? Like, have you seen any changes?
Yeah, what I've seen is that certainly on larger projects, the GCs and the CMs have gotten much more savvy about either conditioning or qualifying their price, um, less so now than right sort of in the middle of COVID, where I advised several clients and said, you can't really ask for several owner clients I advised that you can't ask for a contractor to say, this price is good, and we have no idea what COVID's going to do in 6 months or a year. So what I advised them to do was to say, if it is more than what the situation is now, then you can prove how that impacts your cost, then you would be entitled to additional compensation. Some toyed with the idea that if it got better, that they would give money back, which I think is problematic. It's equitable, but it's problematic to work out. But what I see now is it's more about escalation and supply chain disruption, volatility, that is part of the conditions of the contract. I don't think owners are putting it into the contract, but I think that contractors to owners and subs to contractors are putting qualifications that, this assumes no significant increase in the lead time on these products. This includes no disruption due to, a boat getting stuck in the Suez Canal or something like that couldn't be anticipated. They're being much more express that their contract price does not include that. And I think to the extent in the private world, owners are recognizing, okay, maybe we play with that language a little bit and make sure it's clear and even. But I think there is some recognition that if things significantly change, not a little, but if things significantly change and that increases cost, that's not a terrible agreement to get either a contractor that you want or get a price that you want amongst the options that you have.
When it comes to managing the contracts, right? Say in a contractor world or even in a subcontractor world, the project management team who is managing the contracts. My question is, how do you strike a balance between getting the work done, maintaining a relationship, but then also managing the contract?
It's difficult. There's no doubt about it. I've been a project manager, and there are different levels within any project. And I think that good companies recognize that. And it's important that the executives, maybe even, the president and CEO, depending on the size of the company, have a relationship, even if it's occasional, to talk things through. I'm a fan of formal or informal escalation of disputes, meaning that the project level people try to resolve it. If they don't resolve it in a certain amount of time, or it seems to be lingering by one party, that it moves up to, say, a project exec or a VP or a regional GM, something like that, that has a little bit bigger, broader perspective to say, is this something we can resolve and move on? Or is this something that we really need to fight? And then if it doesn't, at that point, you can roll it up even further within each company. And I find that when there is some sort of a process like that, I think that causes the executives to connect during the project and build a more of a relationship between the two companies. And that always provides an escape valve to let the steam off and not let a dispute blow up. That being said, I think your question's more, how do the people on the site manage this, right? Because that's where the disputes are going on. You're fighting every single day, and everyone's trying to get that inch and not give up that inch. I get it. What I always used to try to do, and what I used to advise project managers to do, is first, most important, is if you go back and forth with someone in an email, before you send your third email in the same day, pick up the phone. Right? Pick up the phone, call that person, and you know what? You may be able to resolve it in a 5-minute call. I mean, you may not. You may end up screaming at each other and hanging up on them, one on each other, and that's okay, right? That happens in construction. But I think you always have to give that person on the other side the opportunity to actually surprise you and be willing to understand where you're coming from. I think that works very well because people will recognize that you're not creating a paper trail. You're trying to resolve something, right? Because once your counterpart is writing everything you said, you just said this, and I think this, and you said that, everyone gets their back up. They don't want to be in that situation. Now well, you said this, and it goes back and forth, and that doesn't really help anybody. So I say big time, not text, not email, just call that person and give it a shot. That's one thing. The second thing is, always think about helping that other person help you. And what I mean by that is I see lots and lots of emails, particularly because I think people write emails quick and shoot them out, whereas letters, there's a little bit of review and maybe somebody else looks at it. But with emails, I always say rewind 30 seconds or a minute and maybe put I want to talk to you about, and give them one or two sentences so they are coming right into where you are going to ask them something or you're going to tell them something. So they know where you're coming from. Maybe you attach a document. I got this RFI and I don't agree with it, blah, blah, blah. Well, maybe you take one step back and say, do you remember the RFI? I've attached it so you can see it. We have a difficulty with understanding X, Y, and Z, right? Now that person has the RFI right there, or has the letter you're referring to, or has the soils report, or whatever it is, right? The concrete test. And they don't have to go find it. They don't have to write you back and say, send it to me, right? You've given them that information. You've made it easier for them to read your email, have all the information there. Now, that doesn't mean they're going to come back and say, Sid, whatever you want, that's fine with me, right? Thanks for sending me that RFI. But it prevents someone going, oh, crap, I got to do this. I don't have the time right now. I'll get to it in an hour, and an hour turns into the next day or the next day or the next day, right? People that look at it and go, okay, he's given me what I need to see. Let me just take a quick look here. I'm eating my sandwich. I can read this thing. I remember it. I just have to refresh my memory. Okay, yeah, okay. And then he writes back to you and says, Sid, here's why I don't agree with you, right? And he actually tells you, right? Because he has it in front of him. So I think that's another one. But I think that probably the biggest thing is tone, right? If you write an email and it is accusatory, if it uses words like, you're not acting in good faith, or, why are you such a, blah, 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 blah. Those kind of emails, you just don't send them. They don't go anywhere. Everybody has a personal ego that when you do that, especially in construction, they're coming back at you. They're not trying to solve your problem. They're not even listening to you. They heard, I was just personally attacked. Now, what can I say about this guy? And write right back to him. And oh, by the way, I'm going to CC his boss and my boss, so everyone sees what a jerk this guy is. And now everyone's focusing here, and all you wanted to do was focus here. So you have to think, how can I help them? Is there a way I can call them? And what's my tone? Let's think about the most factual, yet at the same time, you want to be a little bit persuasive. Give him a reason why you're being reasonable. Give him a reason why he should decide the same way as what you're suggesting. It takes a little bit longer, but if you get in the habit of it, it ends up being very, very fruitful in being able to get your point across. And if you're being reasonable, more often than not, the person on the other side is going to start to realize, this guy, every time he sends me something, it's pretty good. Whereas if every time you're asking for something, it's kind of BS, people figure that out really quick. And then they think, oh, I just got another email from that guy. It's garbage. I don't even need to read it. I'm going to just write no and send it back because I know whatever he says is garbage. If you want to flip the script and say, okay, this guy, not that they would use these words, but he's a worthy adversary. He's making my life difficult because he's strong on the facts. He's being persuasive. Okay, this one I think he's right on, and maybe I got to go talk to my boss and see if we can, get him this small change order or allow him to work there over the weekend or whatever it is. So there's a lot of things, but those would be the three that I would recommend off the top of my head.
Yeah, I really like those three advices, and maybe you also touched upon it, but when we're talking about emails and when it goes to litigation, right? What are some of the pointers that you would say a good documented email will look like?
Right. So I'll flip your question to the opposite of what you asked, and then I'll circle back. So we spend lots of our time looking at project documentation, and in today's age, there's tons of it that's email. And as I say, people generally don't think through emails. People don't even proofread their emails. They're emotional and they're quick. And sometimes people say really dumb things. So when I have a new project, one of the first things I do, we usually have them in document software so we can sort and filter them in a very good way. So everything is OCR'd, so we can scan. We'll have 50,000 emails, and we'll scan on a word. When people are really emotional, they swear. So we run searches on all the swear words because that's really what's got somebody fired up. So we usually know that that's probably something important. And you'd be surprised how many times people dropping F-bombs and, saying other nasty words, it leads us right to what is going on in the project, right? Really simple thing. So don't swear, right? Don't swear. Um, the second thing is kind of tying back to what you said. That's a not good way to do it. A good way to do it is along the lines of what I was saying earlier in trying to help the other side, help you, and trying to moderate your tone. You have to remember that when it gets to my world, it might be a 3 or 5 year long project, another year or two before we get involved. So we may be looking at an email that's 5, 6, 7 years ago. The person that wrote it no longer works there. Maybe people know where they are, maybe they don't. So we just have this email. So we are interpreting, probably next to texting, the worst form of communication known to man, right? It can be great, but there's so many times where innuendo or satire or trying to be funny doesn't work, and it looks terrible, and it's so hard to interpret. So I would say avoid those things and think about how people will view your email down the road. So best emails for me are the type of emails that say, here's the problem, maybe a document or two that attaches it. Here's our position, and here's what we want. Because when we're looking to try to piece back together the project, figure out where problems happen and who's responsible, the most important thing for us is we want to know what people were thinking contemporaneously, meaning what were they thinking at this given point. So we look at schedules and we see, oh, I've got a job right now, and in October of a certain year, all the schedules started to slide. So all the emails in September are really, really important to us because we can't tell right now. We've only been on this job for about a month, but we can't tell whether everyone knew the schedule was going to start sliding or whether no one knew it was going to slide. And so we're trying to piece together what people are that we don't have access to ask. What was going on in September? And so far, it looks like nobody knew that the schedule was going to start to hit real problems the following month. So we're always trying to find what was somebody thinking, what was somebody telling someone at a particular time in the project. So that helps us not look at the project in hindsight, but try to look at it in real time as things were going along. So if you think about someone trying to understand the project, not every email is going to be like this, right? I mean, there's plenty of the emails that say, are we meeting at 10? No, at 9. Oh, I can't make it. Can we change it? Right? We don't care about those emails. We care about what are the disputes? What were people doing to try to figure out the problem? What were people's positions at that time? Because when you get to litigation, I have a litigation I'm involved with right now, and the theories that are coming up in litigation are nothing like what was discussed during the project by the other side. So that'll be fun to kind of say, when did you come up with all these theories? Because we have all the emails that were saying, no, they were thinking something different, and now they've changed their position, I won't say 180, but quite a bit. So, I think just, the same things I was saying earlier, try to explain where you are so that, attach documents if they're meaningful. Watch your tone, watch the language. It's funny because on some jobs where we look at, thousands of we'll say, key emails or letters, you start to almost be able to tell what somebody's personality is. You can see the hotheads, right? You can see the people that are very, very meticulous in every single thing they do. You can see the people that care. Just pay me. That's all I care about. It's really kind of humorous. I never would have thought that's possible, but I've met many, many project managers, and I walk out of the room after I met them, and I go, "Yep, I had that guy pegged perfectly." Just from reading, hundreds of his emails, you kind of get a sense as to their personality. So, but it's important. It's super important. And the other thing is important when we're talking about communication is to make sure you do send the emails. There are occasional jobs where we get involved and there is a dearth of email. There was a huge issue. And we look through the emails, and there's almost nothing related to this supposedly huge issue. And we're left with the decision: did they just not put it in email, which doesn't seem likely, or is this wasn't really a big issue at the time? So if there is an issue, you do want to put that information down. Again, not contentious, not accusatory, but documenting. If you're an owner and a contractor submits a schedule and it's overly aggressive, no way are they going to meet it, then you should write back an email that says, we don't agree with the dates in your schedule. If someone is looking for compensation and you don't agree with it, it would be nice to say, we don't agree with it because the contract says you're not entitled to it, section whatever. When they don't say that, we've had situations where someone submits a change order, a significant change order, and there's no discussion in writing from the other party for months and months and months and months. And what were they thinking? What was going on? And it's easier to define it then, what the position is, than to go back later because people don't believe it because it's not at that time. It's not contemporaneous.
With so you've probably dealt with a lot of different type of projects. I'm curious to know, um, is there like a specific type of project or industry that you see more cases often, like maybe comparing a commercial construction to a civil construction? Where do you see the disputes more often?
Um, no, not really. I mean, subsurface construction, anything that's in the ground is inherently dangerous because you can do borings, you can do soil testing, but it's usually only in that locus of wherever that is. And as we know, your rock goes up and down, the moisture changes seasonally. There's a lot of things that change under the surface of the ground. Um, but that's what differing site conditions clauses attempt to try to, you know, prevent costs being included in the bid to deal with those things. The I think that from a industry to industry perspective, I don't see much of a difference. I generally work in three areas, because of my background. I spend a lot of time in roads and bridges, DOTs, with a little bit of rail. I spent a decent amount of time in the curtain wall industry, so I know buildings. Um, and I've done a number of water treatment, wastewater treatment plants. As far as there's plenty of them out there, and they're constantly doing so. Three very different types of project. I don't think one is more litigious, one is more dispute producing than others. I think they all share problems, and maybe none of them are true successes or true true solutions to the problems. I mean, the contracts may be different, the schedules are different, the processes are different, but I think they all come from construction as a basis, and I think that there's problems in all of them because we can't predict everything, and not every design is perfect.
Got it. I mean, we talked about industries. What about different parties or entities? So, say like if there's a legal issue between contractors or contractor owner, and comparing that to a legal issue between contractor owner versus a state, do things change? And if yes, like, what does it look like?
Yeah, there's a little bit of a difference. In my experience, when a state, say a DPW or a DEP or a DOT, one of the large agencies in a different state, um, oftentimes the dispute resolution is slower. It takes a little bit more time. Um, there are oftentimes statutory language that has to be followed in state projects, public projects that don't have to be followed in private jobs. And I think sometimes there is, in particular cases, there may be some media or some political pressure to either settle or to not settle based on taxpayer dollars when you're dealing with a state entity. On the flip side, I think that with private entities, the biggest difference is that there often is a value put on the continuing relationship. So I've seen many times where subcontractors will settle for less money, provided they get a future job or they get the opportunity to bid on a particular future job to have more income down the road. I also think that sometimes the dispute resolution process, the documentation, the quantification of damages, sometimes two business entities that are focused on profit and loss will recognize not every I needs to be dotted, not every T needs to be crossed, because they know where it's going to end up. And the difference between doing that work is insignificant in the overall dispute dollar amount. So sometimes you get to a certain point and then it's simply negotiation between the two parties, recognizing that they've done what they can to get pretty close, and that's good enough for a private party to private party negotiation. Not to say that that's across the board, but I have seen situations where people are looking at future relationships, and there might be a sense of, why am I going to make this guy spend another 2 weeks having people run around, get all these documents, when at the end of the day, I know where I'm going to end up settling this thing. Why don't we just sit down and, businessman to businessman, make this thing work? Once it's been developed that there's entitlement and that the costs are reasonable. I see that. Whereas in a state situation, that would be pretty rare.
Interesting. When it comes to technology, um, just in the field of contract management or construction law, if you compare like early 2000s to today, what changes have you seen, just contract management itself?
Well, I think that most sizable projects now use some sort of project management software, Procore, eBuilder, one of those. And I think that um, that's good. You've got one place where all your documents are. I've heard, different advantages and disadvantages of the different softwares. I think that the thing people like is that the routing of change orders or payment application, approvals and things like that. It's all automated and instantaneous, which, you know, 20 years ago probably was the exception, not the rule. Um, I think that with COVID happening, I've seen some sizable companies going into like wearable technology, the hard hats with the 360 cameras that's then dialed into AI or the BIM set up so that they can progress the site or status the progress of the site. And I've heard some very good reports on it from people that I know have used it. Drones is great to identify what's going on, to get access to things. There's some legalities about where you can fly them and how they can be used, but that's a great tool that wasn't there 20 years ago. There's a lot of other things that are in the formation stage that I see a lot of things being thrown out there, and some are just going to die on the vine and we will never hear about them in 2 or 5 years. And others that we don't even know about now will become commonplace in 10 years. And that's exciting. It's hard to keep track of all the different aspects and all the different, technologies and startup companies that are out there. I actually just read an article, brief article, on something called smart contracts that are hooked into Bitcoin and or blockchain rather. And I was to be honest, I had no idea what they were talking about. And I reached out to the author and said, "Please tell me more. I've never heard of this, and I don't know how this would work." And he said, "Well, honestly, I don't think it works anywhere right now, but I think it's coming." So I said, "Okay, well, this is interesting because I like stay in front of where things are. But yeah, there's a lot of technology out there. It's never been easier to have an idea and be able to develop it, scale it up, and bring it to market. And I think certainly a lot of the big companies out there, a lot of the contractors are trying it. They're trying things and saying, okay, let's pick a number of projects, let's give it a shot, and then evaluate in a year and see, what's our ROI on it, right? Is it beneficial to us? Is it still got kinks it's working on? Is it something we can improve? And I think that it's, as I say, very exciting for where this is all going to be in 5 or 10 years.
Awesome. I've enjoyed this conversation so far, and I usually like to end the session with one tip that you would like to give the young professionals on how they could be better with managing contracts.
It's a good question. I think that I'll give you two, and it's a little bit of what I've said before, but I'll wrap it into a twofer. One is read the contract, right? I think that many younger construction professionals are intimidated by the contract. There's a lot of language that's difficult to read. Um, what I would recommend is, if there is a senior level person that, maybe you have a mentor, officially or unofficially, that you feel comfortable asking all those questions for, ask them what the key parts of the contract are, right? I mean, contracts can be a couple hundred pages with everything in them. And I think that the scope is really important. I think the schedule is really important. And I think a lot of the general conditions are very important. You probably don't need to worry about the insurance unless you have some particular aspect about it. You don't need to know about indemnity or the ownership of the design documents. Those things are not the meat and potatoes of the contract. But I think reading them, and then when you see something, asking someone, hey, do you know what this means? I don't understand this language. And the internet's a good resource to try to find what that is talking about. You could type in the exact language, and you might even find a contract online that explains it. So I think it's really important to know, because I think that there's a perception, certainly among the older portion of construction professionals, that, well, I've done 10 jobs, I've done 100 jobs, this contract's going to be the same as the last one. Well, probably 90% is correct, but that 10% might be really, really important. So you need to read it for each job and know it, right? And like I said, there's going to be the scope, the general conditions, and maybe a few other pieces that, as an APM, as a project engineer, you may want to have that on you at all times. Just have an important, put the schedule in there, the last payment application, have those key things. So when someone says something, you can go back and see what it actually says. So that's one thing that I think, if younger people would read the contract and try to understand it, albeit I know it's difficult, but try to understand as much of it as they can, that will help them. Because at some point they'll say, wait a minute, I don't think the contract says that. I think it says that we have to do this before we can do that, or we're not entitled to this, but we are entitled to that. And some older senior project manager says, what are you talking about? And you can pull it out, and they go, well, I didn't read that. Okay, score one for the junior guy, right? The second thing that I would highly recommend is to make sure that you are documenting things, not just for that moment, but so that if down the road there is a dispute or a litigation or something, change order request even, and somebody wants to piece back together what happened 3 months ago, 2 years ago, that your records can be used to do a lot of the legwork on how many people were there, what the dates were, what was someone doing on. I actually gave a presentation at the CMAA conference last year, the annual conference, and the title of the presentation was something along the lines of good examples of bad documentation and the lessons that you can learn. And unlike most presentations at those kind of conferences, most people get up and they tell you all the things that you should do. So it was kind of a spin on that. We got up and showed example after example of really, really terrible documentation. And then we explained why it was so terrible. Although usually we put it up on the screen and everyone started laughing. And then we would see in the audience people start to cringe a little, and we'd say, you've done this before, and we get some nodding of the heads, and it's okay. Well, we have all done these things, right? Because being a project manager is difficult. Document as best you can. We understand. I understand as a project manager, there's never enough time. There's never knowing what's going to be the problem down the road. So you just have to document things as best you can, and it's always, always, always going to be beneficial to you.
Do we have the recorded link of the CMA presentation?
It was last year's 2023 CMA annual conference. I don't know if I have it. I'll send it to you. If not, it might be on the CMA website.
I personally learned a lot about the construction law and contracts and how to manage it, and hopefully I can implement some of it in my day to day. Greg, if anyone wants to reach out to you, what's the best way?
I give you my email address is Greg Holness HOLNESS at Arcadis.com. Feel free to reach out to me.
Sounds good. Thanks, Greg.
Thank you, Sid. Take care.
Thank you for tuning in to Constructing Tomorrow. I hope this episode provided valuable insights and tips. Don't forget to like, share, subscribe, and drop a review or a comment. Until next time, keep building and stay curious.